Welcome to the Lunch and Learn, technical conveyancing training as part of National Conveyancing Week. Today's Lunch and Learn is hosted by Quayle, a training consultant at IQ Legal Training.
So let's have a look at some interesting things. First of all, useful websites. Again, you're not litigators, I imagine, you're transactional property lawyers, but I do like the PLA website. It used to be free access, now you have to be a member of the PLA to access it. However, if your firm has a litigation team, then I'm sure you will be able to access it, and it contains a wealth of useful materials for residential conveyancing, notably case law, recent case law relevant to some of the work that you will be undertaking. The next site is a site called Property Protocols that you may not be familiar with. Again, it's predominantly a commercial property site. It is free to access, but there's something on there that I'd love you to have a look at if you've got time, and that's something called the Boundary Dispute Protocol. I'll just put that in the chat box if I can. And I don't know if anyone has seen it or anyone has used it, but if you haven't, please have a look at it. Why? Because it explains the problems associated with boundary identification in the conveyancing process, both in the context of resi conveyancing and commercial transactions. Secondly, it highlights the steps and measures that can be taken to try and alleviate problems associated with boundary and neighbour disputes, highlighting what is good evidence and bad evidence with regard to boundary identification, recommending a route map in connection with determined boundary applications and or formal boundary agreements. So there's loads and loads of information there that I think will be really useful to you. Can someone just put in the chat whether you've actually seen that boundary dispute protocol? Because as I say, I think it is really, really valuable. And if you haven't seen it, do have a look at it, because hi Zara, it's well worth the look at, Zara, because it tells you about the problems associated with boundary identification, highlights what you can do to ensure clients are properly advised with regard to boundaries. And as I always say to practitioners, the issue relating to boundaries is an art form rather than a science. And really what we're left with is looking at how boundaries are described rather than plans, etc. So loads of people, hi everyone, by the way, loads of people sort of commenting there. It's not going to take you long to look at it. It's free to access. Download it and share it with colleagues, because it's a sort of a one-stop shop for dealing with boundary issues. And if nothing else, it confirms a lot of the problems that you will have encountered or you will encounter as resi conveyancers dealing with boundaries. And I think one of the most important things there is setting realistic client expectation. Now, I'm going to mention something else now, and I hope people have seen this. The RICS has a consumer guide to survey and valuation. Zara, I know you've seen this. Anybody else not seen it? The RICS consumer guide to survey and valuation, brilliant at highlighting to clients the benefits. Thanks, Zara. The benefits of survey and valuation, and highlighting the importance of level 3 survey. Again, I would provide a client with a link to the guide, or provide the client with a copy of the guide, as well as my advice relating to the significance and importance of obtaining survey. So again, I'm going to open it up to the chat. Has anyone not seen the RICS Consumer Guide to Survey and Valuation? It looks from the silence in the chat. Gemma. Well, again, invaluable, Gemma, right? I'm a great believer in finding resources that mean that we can reduce the amount that we're including in our retainer and in our report on title. So if I can use documentation that's well drafted, aimed at the consumer client, I'm going to use it wherever I can. And the RICS Consumer Guide to Survey and Valuation is brilliant in highlighting the importance of survey and valuation, the principles of let the buyer beware, and it's going to enlighten the client without at the same time burdening you with providing more information to the client. And on that note, I mentioned the Leasehold Advisory Service website and the Leasehold Knowledge Partnership, both really useful in connection with leasehold transactions. I do a lot of work for and do a lot of training for the Leasehold Advisory Service, but despite my limited involvement, they're very good at what they do. And therefore, again, there's a wealth of material on both of those sites that I think will be useful for you if you're undertaking leasehold transactions. And then finally, I mentioned Property Law UK, which is a plug. I'm sorry about that. This was a magazine started off by a barrister called Gary Webber at Tanfield Chambers. Gary sort of packed in to go wandering around the world, and I took it over a few years ago. It is a subscription service, but if Jess asks me nicely, I'm sure that we can offer discount to members who attend today. So we'll do that for you as a sort of gift, as a consequence of your being burdened with me and my code and my droning on this afternoon. So what do I want to talk about today? Well, let's have a look at a number of things. The first thing I want to talk about is our friend Common Hold. Why do I want to talk about Common Hold? Because this government, I think, is hell-bent on pushing Common Hold forward. Hot off the press, the Law Society have asked me to write a book on Common Hold, which will be coming out, we think, sometime late in the year. There is a draft bill. I'm trying to get the inside track on the draft bill by working with government. More on that later. But there's no doubt in my mind that the current government has an appetite for Common Hold. The last government, back in January 2021, mentioned that Common Hold might be something that was back on the agenda and formed a committee for that very purpose, but it didn't go very far. The other thing is, I've been asked by a number of firms since November going forward to do training on Common Hold. So I remember Common Hold version 1, courtesy of the Common Hold Leasehold Reform Act 2002, which died a death, having spent nearly 2 years of my life engrossed in Common Hold. And I'm now saying that we're going to see a version of it. My concerns about Common Hold remain. The lack of market relating to Common Hold remains, but I think the government's going to push it. Now, what I think is going to happen is the government is going to say to leaseholders, rather than collectively enfranchise or rather than go down the rights to manage route, we'll create a sort of pathway to enable you to convert into Common Hold. I think that's a possibility. I think the government may say to landlords who have problems with regard to, yes, you've guessed it, Building Safety Act remediation issues, that we will only support or provide grants or funding or facility for you to escape insolvency if you convert to Common Hold. I don't think we're going to see sometime 2026, 2027, all leaseholds being abolished and everything being converted to Common Hold. I think there'll be a slow drip introduction of Common Hold. So what I've done this year is produce a series of webinars, 3 webinars on Common Hold. If anyone's really interested, you can have a look at them and we can make them available. I'm also doing a course on Common Hold later in the year. To be honest, as I invariably always am, I would suggest back off. There's enough things to worry about rather than Common Hold at the moment. Keep off it until we see what the legislation looks like. Zara and Lauren, you're right. Lenders don't like Common Hold. Developers don't like Common Hold. And at the moment, we've got a situation where the market just isn't ready for it. Okay, we've got the bad publicity that existed with regard to Common Hold 1, and I don't think we've seen anything as yet that makes it strikingly or radically different. But I do think it's important that you're aware of what Common Hold is, and that's the purpose really of the first part of this session. So, background: Common Hold Leasehold Reform Act 2002, Common Hold Regulations 2004, Land Registry Practice Guide 60, August 2004, King's Speech, July 2024, government announcing November 2024, we're going to legislate, we're going to push forward with Common Hold. As I say, I'm working with government, working with the Law Society with regard to a text. It's unlikely to be available until the very back end of this year. And again, I wouldn't be wasting my money on doing anything with Common Hold just yet, other than maintaining a watching brief. As far as that watching brief is concerned, we're likely to see, I think, compulsory conversion of leaseholds in very limited circumstances. Perhaps compulsory conversion of leasehold where we've got landlord insolvency. I know Zara's very keen on this. You know, the Building Safety Act and the problems associated with the Act mean that I think we're going to see lots of landlord insolvency. as a consequence of that, we might see the insolvency process pushing leaseholders with insolvent landlords into common hold. Common hold does not, and this is a very important point, it doesn't alleviate or remove the problems associated with the Building Safety Act. A common hold association could be just as much in the mire as a landlord or management company with regard to duties and obligations under the Building Safety Act. So I don't see common hold in its current form doing anything to resolve the mess of the BSA. And as Zara says, yeah, it's potentially going to make a mincemeat of shared ownership. I think that's one of the things that the government department is really looking at the moment. Okay, next thing. Could landlords volunteer or surrender to common hold? Well, that's a possibility. I am talking to landlords at the moment who are terrified of the Building Safety Act and saying, we don't want to be landlords anymore. So they might be a very easy door to push with regard to conversion to common hold at the moment. I don't think we're going to see developers saying, what a great idea common hold is, let's create a new scheme in Milton Keynes with a block of flats and we're going to sell them as common hold. The reason for that is last time when they tried to do that, they thought that buyers would be willing to pay more for the acquisition of a freehold flat rather than a leasehold flat. And of the very limited number of common hold schemes that went live and went active, that wasn't the case. There wasn't a premium paid by buyers of new properties for a freehold common hold unit as opposed to a traditional leasehold unit. So is it a variation of leasehold? No. How does it compare to rights to manage companies? Well, it does compare. It has its similarities. But what you've got, in essence, is a form of freehold ownership. You've got a common hold association, which is a company limited by guarantee with a statutory format and statutory constitution, with very little opportunity for variation or fluctuation with regard to design and content, although there is provision for the creation of what are called local rules, which could be exclusive to a common hold unit in Carlisle and a common hold scheme in Truro or in Tunbridge Wells might have radically different local rules. And therefore, the concept of a standard sort of common hold community statement replacing a lease, I think, is perhaps to an extent wishful thinking. What we're going to have are common hold community statements, potentially with local rules within them that will be unique to particular common holds. The only excuse me, saving grace that I can tell you about is that the local rules would have to be flagged up in the common hold community statement and would have to be in a particular part of the common hold community statement, making it relatively easy for you and I to spot it and to draw it to the client's attention. So what do we need to know? Well, a common hold association, as I mentioned, is a company limited by a guarantee with a set constitution. Common hold land is freehold land registered as a freehold estate in common hold with a constitution of the common hold association registered excuse me, at the land registry as well. The common hold community statement is in essence a replacement of a lease, but it's not a lease. Okay, it is a regulatory document that regulates the conduct of unit holders, the freeholders to common hold units within a building, formerly the leaseholders within that building, and it sort of ties them together as well as establishing a relationship, duties and obligations between them and the common hold association. The problem with the common hold association is, as we've seen with leaseholder run leasehold schemes, we are dependent on having leaseholders who know what they're doing with regard to the management of a leasehold scheme for the leasehold scheme to be effective. And I think the same principle applies with regard to a common hold. If we have a common hold ran by unit holders, then we're dependent on the quality of unit holders to establish how well or how badly run the common hold will be. One of the things that the government is looking at is a requirement to have a professional director of a common hold association, or an obligation on the common hold association to appoint a professional management companies to run the common hold. The problem with that, well, first of all, let's be positive. The advantage of that is that we'll get over the problem of leaseholders, common hold unit holders running badly the scheme. But the downside of that is cost. So I could see unit holders being very aggrieved where they are compelled to have an expensive management company running the common hold, or a professional director, again employed and paid, we can imagine, quite healthily for their services. So there's a sort of a double whammy with regard to that we need to think about. Common parts of the common hold are owned by the Common Hold Association and are basically the default. Anything that isn't a common hold unit would become common parts. Yeah, Zara, yeah, it could be well run if people are educated. But I think, even though people have the potential to be well educated, courtesy of the Leasehold Advisory Service, with regard to current leasehold schemes, they frequently do not take the opportunity to ensure that they are properly educated with regard to management. Common Hold Association is owned by unit holders. However, developers do have a say with regard to the Common Hold Association, pending the sale of the last common hold unit within the scheme. As far as common hold documentation is concerned, the common hold community statement is the key document. It governs how the common hold is used and managed. It has standard provisions, but also includes local rules. It identifies common hold units and apportions the common hold assessment, which is the modern version, the common hold version of service charge amongst unit holders. Hopefully, as it is unit holder owned, it will act in the best interests of unit holders. That seems to be the true sort of intent sitting behind this. As far as local rules and additional provisions are concerned, our common hold community statement might have local rules, but certain clauses within the common hold community statement are compulsory. Compulsory provisions, as per the slide: use of reserve funds, permitting creation and management. One of the interesting things you can extract from the BSA and the sort of reform of leasehold ownership is just how important reserve and sinking funds are to enable funds to be established to defray items of unusual expenditure that could be incurred at points in the future. So rather than the unit holder or the leaseholder in the current year being hit with a huge cost where future leaseholders or unit holders will derive benefit, the reserve or sinking fund is created by a wider group of entities and the cost shared and the risk associated distributed more evenly. So that's a good thing. As far as directorships are concerned, the questions and issues about whether or not someone should be advised to accept a position as director or secretary of a management company, particularly where that management company is responsible for building safety issues in a higher risk building, that dilemma, that sort of risk would apply to directors of a common hold association as well. There isn't some sort of blanket or protection for a director of a common hold association with regard to risks associated with insolvency of the common hold or liability arising from Building Safety Act or indeed other statutory measures. So again, I don't see how we're going to get people running and skipping along saying I'd love to be a director or secretary of a common hold association. Other issues: compulsory provisions, diversion of rent to the common hold association where a unit holder hasn't paid their contribution to the common hold assessment. Limitations with regard to leasing but permitting short-term lets. Dispute resolution provisions within the common hold community statement as opposed to litigation via the county court or first tier tribunal. And an interesting one, the transmission of rent arrears on sales of units. So if there are rent arrears owing on by a seller of a common hold unit, that liability is transmitted to the buyer on completion of the purchase. The thinking behind it being that no buyer properly advised would be willing to proceed with the purchase of a common hold unit in the knowledge that there was rent outstanding. Compulsory provisions, again, we've talked about some of those things. Development rights we haven't mentioned. The idea behind development rights is that a developer, the site owner who sets up the scheme, retains development rights to develop other parts of the scheme, airspace development and this sort of thing. And again, if you're going to buy a common hold unit and buy the freehold to your flat or apartment, I can imagine there'll be some dissatisfaction with development rights enabling the developer of the site to undertake additional development, airspace development in particular, in the future. Common hold association is a common hold company limited by guarantee. Statutory objects, the role of directors, the role of unit holders set out in its constitution, and the idea behind this, just as with the common hold community statement, we're going to be comfortable with dealing with standard documentation. So it's going to be something that is going to be easy to advise on, which again, in theory, sounds fantastic. The reality would be, as I mentioned a little earlier, the fact that we may well see a reluctance of unit holders to become directors of the company limited by guarantee, and we may well encounter professional directors who charge the earth for their services, thus ramping up the cost of the common hold assessment. Zara, do you think people will be adding more stories into permitted development rights if they went to common hold? Well, I think, yeah, a developer might, Zara, because at the end of the day, he's off the hook, isn't he? Because the Common Hold Association takes over, and therefore, not my problem anymore. And again, you'd be amazed how often I'm seeing landlords say that to me. One landlord in particular said to me, he's reducing the size of some of his buildings so that they're not higher risk buildings, because he's so terrified about getting something wrong with regard to Part 4 of the Building Safety Act and going to prison as a consequence. The common hold unit is described in the common hold community statement. It is a separate freehold title. There are common parts which are similar to common parts as we'd see in connection with a leasehold, and there are limited use areas where, for example, cars can be parked or bicycles stored, etc. The common hold community statement makes provision for both of those things. Again, the other important point is anything that isn't a common hold unit becomes a common part. So things like definition of structure are to an extent an irrelevance. Right, so that covers off common hold. In short and put simply, one, we're going to see it in some way, shape or form, unless something dreadful happens or something good happens to this government, depending on your political view. I don't think it's something to get worried about just yet. I think forewarned is forearmed, and I've done as enough forewarning as I possibly can, I think, this afternoon. As and when we see the draft legislation, then you'll see a book coming out from the Law Society, and I'm sure you'll be bombarded with training opportunities. But as I say to firms that are asking to do training on common hold at the moment, there's no point really until we see the draft bill, because the common hold in its current form didn't work and wouldn't work. Okay, so if anyone has any questions about that, let me know. Zara, what about charging the Section 106 to third-party management companies for maintenance of estate areas? Well, again, the Common Hold Association, Zara, acts as a landlord. So again, as far as that is concerned, for maintenance of estate areas, it is responsible. As far as 106 agreements are concerned, I don't think the planning legislation as such is sophisticated enough to deal with the Common Hold Association coming into the fray. I think that's something that has to be looked at. But good point, Zara. Thank you. Let's go on to something a little happier. Reporting on title and leasehold transactions. First question, how many people now are using electronic reports on title? Most of the search companies have, in one shape or form, a form of electronic reporting on title. So I'm interested to know how many people attending today are using those reports on title. Can I say that I've looked at the majority and have been moderately impressed with what has been produced. And therefore, as a guide or a framework, as a template, I think they're good. I think there is opportunity for improvement and fine-tuning. And yet, Laura, your own precedents may well be more than satisfactory. Do be careful to make sure that you are taking into account BSA related issues. And I know some people are going to say that are attending today, we don't do BSA related work. Well, I'm going to upset you, because what I'm going to say to you is you may not think you're doing BSA related work, but in fact you are. You might be acting for me purchasing a flat in a 4-story building that's less than 11 meters in height. So you might say to me, the Building Safety Act doesn't apply to this building, and you're right, currently. However, if the landlord undertakes airspace development in the future, the 4-story building that is less than 11 meters in height could all of a sudden become a relevant building. That doesn't worry me that much. It could also potentially, if there's a large airspace development, become a higher risk building. And that really does worry me. A, because service charge is likely to rocket. B, duties and obligations on landlord increase dramatically. And terms are implied into residential long leases, and additional duties and burdens are imposed on leaseholders in those circumstances. So I'm not asking you to write an essay on the Building Safety Act. I am asking you to say to clients where the BSA doesn't apply. It doesn't apply currently, we think, but it could apply in the future were the landlord to undertake some form of airspace development. Yeah, airspace development is an issue, Zara. I did some work, shows you how really sad I am, after Christmas, looking at how leaseholders could successfully block a landlord that wanted to undertake airspace development. And there were loads of cases on that topic. I could only find one case where a leaseholder had successfully blocked airspace development, and they'd blocked it on the basis of an infringement of a right to light. Okay, yes, send me the videos, Zara. I'd be interested in it. Okay, so reporting on title in leasehold transactions. What leads to claims and complaints with regard to reporting on title? Well, point number one, failing to ensure that the report on title is consistent with your retainer or engagement letter. You shouldn't be saying that you're doing things in your retainer or engagement letter that you're not reporting on. And equally, you shouldn't be reporting on things that you stated in your retainer or engagement letter that you wouldn't be doing. There needs to be consistency between the two. The next thing that is important with regard to reporting on title is to make sure that messages that you're sending to clients are received loud and clear. That means I think we should be using interim reports on title in leasehold transactions. I would always suggest that we report on the lease independently to our other reports or interim reports that we're submitting to the client. Do the simple things well. If you're sending a report on title to the client, tell the client you're going to assume that the client's read it and understood it unless they tell you something to the contrary, and ask the client to confirm to you it's been read and understood, and ask the client to confirm whether they have any questions or queries. If the client does raise questions or queries concerning the report on title, do make sure that you respond in writing to the client so there is evidence as to what they were asking about and evidence that you had provided the information that was required of you. Important when we think about reporting on title, the retainer in leasehold transactions, that we identify our client and we identify client objective. And we ascertain risk associated with both of those things. So if our client is wanting to use the flat as a buy-to-let investment or using it for Airbnb letting, you can just about bet that in the vast majority of residential long leases, Airbnb letting will be prohibited in some way, shape or form. I normally state that unless Airbnb letting is specifically permitted, then the lease is likely to contain provision that it is not permissible. Same thing with the likes of keeping of pets, etc. So client objective is important. Is there risk associated with that objective? The client, is there risk with regards to the particular client and indeed the transaction? And we need to assess risk with regard to other parties that are involved in the transaction. Seller and buyer, conveyancer, landlord, etc. Interesting point on that. I saw just recently some LPE1s provided by a landlord with a disclaimer on the LPE1, and the disclaimer disclaimed liability for any incorrect answers or information in the LPE1 and in any documentation that was submitted ancillary to the LPE1. So again, as far as that's concerned, there is risk associated with such provision. My view is I doubt that that provision is in fact enforceable, but it was present and evident in the documentation. Scoping the retainer, we require clarity. What are we going to do? What are the limitations relating to what we're going to do, and what are we not going to do? Well, let's look at this in the context of leasehold transactions. How many people who are attending today would give me advice relating to the 3-year service charge accounts that are produced by a seller where we're taking the assignment of a residential long lease? So how many people here would troll the accounts and provide me advice relating to the accounts? Zara says she does. Okay, that's fine. Anybody else? If you're sufficiently competent to be able to do it, I have no objection. But yeah, an overview, but not an in-depth analysis. Well, I'd make that clear to the client, Zara. Okay, and say to the client, if they want specialist advice, you can recommend forensic accountants or others that can provide advice and guidance relating to accounts that are produced. But I think the fundamental point here is that you should be saying to any client of yours who's taking an assignment of an existing residential long lease that the previous year's service charge accounts are not sufficiently reliable to provide evidence as to what service charge will be going forward. Remember, service charge is a contractual commitment on behalf of your client to pay unascertained and unascertainable future expense. So yeah, service charge could increase rapidly due to Building Safety Act issues, particularly with higher risk buildings. But service charge could increase dramatically in any event due to cost of living expense as contractors' costs increasing, etc., etc. So clients need to know that just because 3 years service charge accounts are being produced, so the service charge for the last 3 years averages at £1,000 or so, that is not an indicator as to what the service charge will be going forward. You can also explain to the client the potential protection provided by Section 19 of the Landlord and Tenant Act 1985 with regard to service charge only being payable insofar as it is reasonable. So the report needs to be consistent with the retainer. I think in the retainer, we need to provide information in leasehold transactions in connection with a bigger picture relating to leasehold ownership. Remember the CQS guidance that was revised a couple of years ago? It highlights the need to explain to clients buying leasehold property the bigger picture, the radical difference between freehold and leasehold ownership. I think it's important that we do that. And we either do that in the retainer, or we could provide information sheets to our client on receipt of instructions with regard to the vagaries of leasehold ownership. We could then confirm or reiterate those points in the report on title that we produce before exchange of contracts. Zara mentions that, yes, sometimes you don't get proper accounts. I'd be very wary about making sure the client understands and appreciates what we mean by an overview or in brief exploration of service charge accounts that are produced for us. I think our role is to see what the lease says with regard to the provision of services, to see what the lease says with regard to the landlord's ability to recover cost associated with the provision of those services, and then take things from there. I mentioned retainer creep, saying you're not going to do something in the retainer, so you're not going to advise on the extent or scope of a reserve or sinking fund, or you're not going to give advice in connection with BSA related issues, and then during the life of the transaction, for whatever reason, pressure from estate agent, pressure from seller's solicitors or seller, or indeed pressure from your client, you're now giving advice on an area which in the retainer you said you wouldn't be advising. In those circumstances, you do need to expand the retainer so the client understands that what you're going to be doing with regard to the additional issues, and to make sure that you cover off or fence off the advice that you're giving. That will also give you an opportunity to have a look at whether or not you need to revise your fees. Last point on the slide, no matter what you say in the retainer or indeed in the report on title, no matter how you attempt to eliminate or mitigate against risk, you are obliged to report to your client anything that you become aware of that's materially adverse to the interest of the client, whether that's within or out with the retainer. Lots of case law on that point if anyone's interested. Remember, you owe a duty to provide information, but you've got to go beyond that and provide explanation and, where appropriate, provide advice. As far as the provision of explanation is concerned, for example, you couldn't just give me or send me a copy of a lease or a copy of a TA7 form, there would be an obligation on you to explain its significance in the conveyancing process, and also to explain to me or to highlight to me risk associated with those documents. Generally speaking, with regard to risk, other than risk associated with title, your task is simply to highlight to me the existence of risk and to explain what steps or circumstances you can take, or I can take as a client, or a third party can take on my behalf to identify the extent of that risk. As far as explanation is concerned, again, if you're looking at a document and if there is vague or ambiguous provision relating to that document, you need to tell the client about it. You need to explain to the client the only way of resolving the vagueness or ambiguity would be either for the document to be amended or for the matter to be tested by the courts. Always important when you're providing an explanation to the client to identify client objective, and always important to exercise caution where there is anything that's revealed to you that has the potential to generate risk. Next slide we'll just have a look at. You are under an obligation to explain documentation, explain due diligence, explain your role with regard to due diligence and the limitations of your role, to explain where you are relying on third parties such as search providers, etc., and to explain to clients the conveyancing process as best you can. Now, again, common sense prevails. You can bombard clients with too much information. I was talking to a firm just recently whose report on title ran to 90 pages. And the point there is a client really going to read 90 pages of information from you in an email? And therefore, you might think about, as I mentioned earlier, the production of interim reports on title. You might want to think about producing a summary in your final report highlighting key issues or areas of extreme risk or areas of risk relevant to client objective. If you're going to do that, it's important that the client understands that although you've highlighted areas of particular risk, everything that you've reported on has the potential to generate risk in the future. So, for example, I was talking to someone last week about trees. Their client was buying a lovely property in the outskirts or on the outskirts of Sutton Coldfield. The property's garden was tree lined. The property abutted a busy public highway. So was the client advised about the potential liability relating to the property owner on purchase of trees falling onto the highway and causing death or damage? Was it explained to the client that the client was under a duty to keep the trees that abutted the highway and could fall onto it under review to assess their state and condition? And if the state and condition of the inspection revealed that a tree was damaged or diseased, that some form of remediation work, felling or lopping, would be necessary in order to fulfill the landowner's duty. I mean, do you explain that to clients? Again, with regard to leasehold, do you explain to the client just how draconian forfeiture is and just how risky forfeiture is and just when forfeiture can arise? We need to think about clients in the conveyancing process generally and in the leasehold process in particular. What's the client's objective? What does the client need to know? And is our communication getting the key messages across to the client? As I say, the idea of 90 pages of information being produced to a client in one hit, in my view, is a recipe for disaster. Providing interim reports on title of 15 to 20 pages, highlighting key issues that could impact on client objective, far better in my view. And harking back to the point I made at the very start of my presentation, using external resources to support the points and issues that you're highlighting or making, again, can be very useful too. Common errors with regard to communication. Failing to identify or report on basics, what's contained in the official copies of the register or documents of title. Interesting point that I just discussed with someone this morning. Just because restrictive covenants are listed in the charges register of a registered title does not mean that the restrictive covenant is enforceable. Does the client understand that? Does the client understand that a restrictive covenant could be subject to an application under Section 84 of the Law Property Act 1925 to vary or remove it? This sort of thing. Failing to provide an executive summary, again, can create problems. And have a look at this book, Risk and Negligence in Property Transactions, published by the Law Society and edited by a barrister called John DeWall, KC, a really nice guy who knows what he's done. It's quite an old edition, that now, but contains lots of useful information about making errors with regards to residential conveyancing transactions, both freehold and leasehold. Okay, reporting on title in leasehold transactions generally. We've already discussed the issue of the bigger picture. No, Zara, it wouldn't. But what you do is you have provision to say that I'm picking out what I think are pertinent issues relevant to your objective, but everything in each interim report needs to be carefully considered by you. I did see a negligence claim years ago where a firm in an executive summary highlighted issues, but didn't refer to the fact that everything in the interim reports were important that the client clearly needed to consider. And it was an unreported case, I think, but the court said, well, in drawing to the client's attention these things, you're immediately minimizing the other things in the report. So I thought, right, as a consequence of that, I see how you could deal with it, and that's the way you deal with it. On the issue of term, again, a depleting or reducing term reduces value. Clients need to understand it. The fact you now can't have a monetary ground rent means that we've got a dual system. So I might have the opportunity to buy a flat in a new build in Liverpool. Along the road, 3 blocks along, there could be a flat that is for sale by way of assignment. The old flat has a standard ground rent and ground rent review provision. The new lease has a peppercorn ground rent. That will impact on marketability, viability, and price of those two properties. We've already explained problems associated with service charge. And again, important for clients to understand that a lease involves them in a contractual commitment to pay unascertained and unascertainable future expense. With regard to repairing obligations, it's important for the client to assess the repairing obligations imposed on the leaseholder, but it's also important to ascertain the repairing obligations that are imposed on the landlord. What's the landlord obliged to repair? What's the standard of repair? And can the landlord transmit the costs associated with repair into service charge? And again, lots of resources available on the Leasehold Advisory Service website and the Leasehold Knowledge Partnership website that can support information from the client, information provided to the client within your report on title. Lauren, hi Lauren. We report it works for us, and the client sees them as they ask their questions as we work through the file. They've had reports, management packs, etc. if they need them to refer back to. The other point, Lauren, with regard to that system, and I think is sensible, is, and I don't think this could happen, to be honest with you, but someone said it did once in a file they were working on. Let's assume you found something during due diligence, okay? Surely it's better to highlight that to the client immediately if it's going to be a deal breaker than waiting till you produce the report. So they were saying they always produce interim reports on title in case there's anything that's produced early on that would mean the client would be unwilling to proceed relating to the transaction, and that makes sense. There's a bit of debate on this, Lauren, on LinkedIn a while ago, and again, I'm sure someone mentioned the same point there, that, you know, if you're waiting to produce a report in one large document before you exchange, there could be issues that the client should know about as soon as you become aware of them, to enable the client to decide whether they wish to proceed. Next thing to talk about, really, with regard to service charge is Part 4 of the Building Safety Act and high-risk buildings. Remember, more than 18 metres in height or more than 7 stories in height. But remember, a building that currently isn't a higher risk building could become a higher risk building at some point in the future. Also, be aware of what was said in the Grenfell Inquiry report, that you shouldn't be determining higher risk buildings on the basis of height or number of stories. that the risk associated with a building should be dependent on who's in occupation of the building and their ability to evacuate in the event of emergency. Yeah, Zara and Laura, and I agree with both of those points. So, with regard to Part 4 of the Building Safety Act, which deals with higher risk buildings, a number of things. Firstly, the creation of roles, accountable persons or principal accountable persons. These are entities or individuals that are responsible for building safety measures of parts of the building, normally management companies. Okay, they are required to produce information for the principal accountable person, normally the landlord, that's then accountable to the building safety regulator. No, Zara, they wouldn't be required for relevant buildings, only on higher risk buildings. But a relevant building could become a higher risk building at some point in the future. Remember, higher risk buildings are obliged to be registered with the building safety regulator. The problem with higher risk buildings is that terms are implied into residential long leases, courtesy of amendment to the Landlord and Tenant Act 85. And also there is a risk, given that you've got accountable persons, principal accountable persons and landlords being required to undertake far more proactive rather than reactive work with regard to building safety. Their work is going to lead to greater cost. That cost can be transmitted into service charge. So I think there is a real risk of dramatic increases in service charge costs as a consequence of the status of a building becoming a higher risk building. Part 5 of the Act deals with relevant buildings. Remember, relevant building more than 5 stories in height and or more than 11 meters in height, containing at least 2 residential dwellings. You saw the Blomfield Road case where the first-year tribunal said the government guidance in calculating the number of stories for a higher risk building was wrong. So you now see a warning in the government guidance saying, listen to what we're saying as a government department, rather than listening to what the court has to say. Hopefully this week or next week, that position will be clarified by the Court of Appeal. But currently, we have a position where we're not sure whether we can rely on the government guidance or not relating to height or number of stories. Schedule 8 of the Building Safety Act 2022 provides greater protection for properties in relevant buildings where the leaseholder owns a qualifying lease, but Schedule 8 of the Building Safety Act provides some protection to all leaseholders within relevant buildings, including commercial tenants. The next thing I want to talk about are TA forms, and yes, you guessed it, the moths are out. Why not? Dealing with TA forms, some basic points first of all. 1, the purpose of TA forms is to provide the buyer client with as much information, as much useful information as is possible. And the seller is seen as the ideal resource, as it were, for the provision of that information. So I think the spirit behind the TA forms is that there is a full and frank disclosure by the seller of everything that they are aware of that could impact on the buyer's decision to proceed. The problem with that as a concept is that if I'm a seller, I may have information about the property that I don't want the seller to receive, on the basis it may well put the seller off. We were out for dinner on Saturday night and talking to a friend of ours who's selling a property currently in Harrogate, and we were talking about the moth case, which we'll talk about before we finish today, and he advised that he had moths in his property and that he hadn't disclosed their existence in the TA forms, and his property is currently being sold. So I think he, on Monday morning, went scurrying off to his solicitors to make sure the position was remedied. There is the potential or risk for misrepresentation. Are we seeing more misrepresentation claims? No. Why? Because of risk and because of cost. But we have seen some high-profile misrepresentation claims that have been successful. Perhaps as a consequence of that publicity, we're likely to see more misrepresentation actions being brought in the future. I mentioned Section 2 of the Fraud Act 2006. We do need to be careful. Where a client is deliberately lying, then they commit an offence under Section 2 of the Fraud Act by providing false information in a TA form. Doesn't matter whether the buyer actually buys the property or whether what is said induces the buyer to buy the property. Simply completing the form in a deceptive manner would constitute a Section 2 offence. I'm not saying that you warn every client that they could go to prison if they get something wrong in an answer to a TA form. Excuse me, I am saying if you don't trust a client to answer the questions carefully, or you think they have a cavalier attitude to the provision of a response, I will just give them a friendly reminder about the need to take the replies seriously on the basis that there is criminal sanction potentially available in circumstances where they don't take it seriously. When you're acting for a seller, check what the seller has said with regard to the TA forms against the information that you have on your file. Remind the seller that they could potentially be liable for misrepresentation. Remind the seller of their ongoing duty to update answers if answers or the answers that have been provided are out of date or incorrect. There isn't any legal responsibility on you to verify the information that a seller produces, but there is a legal responsibility on you to check the answers provided by the seller. Yeah, but they don't ask about moths or infestation, Sean, you're right. Going on from that, but there is a question, isn't there, about do you know anything about the property that might impact on the buyer's decision to proceed, is the point there, Sean, yeah? Yeah, they are running to the hills at the moment, Zara, you're right. Meanwhile, back in the slide, important, you are not liable to, in connection with the provision of answers to for the seller with regard to the TA forms. With regard to the TA7 form, I don't think a client can, without assistance from you, complete the questions relating to the Building Safety Act. But what I suggest in those circumstances is you provide an information sheet to the client, referring the client to the terminology that's used in the questions in Section 11, which then would give the client the opportunity to answer the questions that are posed. The next thing with regard to the revised TA6 form is where a seller is producing answers to the questions in the revised TA6 form before instructing you, you need to decide whether you're going to tell the client, having seen the revised TA6 answers, to change them, or whether you're going to simply say to the client, I won't be giving you any advice in connection with any of the answers you've provided before you've instructed me. Matter for you as to what approach you adopt in that circumstance. So, given the complexity of the revised TA7 and the proposed TA6, along with the need to provide client guidance to the seller client, what do we do? I think do as we always have done. Warn the client about their duties and obligations with regard to the TA forms. Warn the client about the warnings on the TA forms. Provide additional information while scoping our retainer to enable the client to answer the questions without seeking guidance or assistance from us. So one of my objections to the revised TA6 is that the TA6 says the client should complete the forms in isolation, but then states in certain questions in the revised TA6 that if the client can't answer the question, then they should seek guidance from you with regard to their responses. If ever there was a mixed message, that is it. Okay, pointing out the warnings on the forms. Warn clients about guessing answers, providing defective replies, answering questions that they don't understand, answering questions through rose-coloured spectacles, and being economic with the truth. Warn the clients about the potential for misrep and, where appropriate, the potential for committing an offence under Section 2 of the Fraud Act 2006. Yes, Zara, an engineering degree may well have been easier than filling in the forms. To fill the forms in properly, you're probably right. Explain what questions are asking about, what they require. Where you're using a revised TA6, make sure the client is aware that they need to take steps and measures as required by the question before answering the question. Rosser and Pacifico highlights that point. You know, if you're answering questions about building regs and planning permissions, you need to check the building regs and planning permissions to make sure that your client, that the property is compliant. Explain you can't give advice on replies provided unless there's information on your file that reveals what the seller is saying is defective. And as I mentioned earlier, explain the duty to disclose changes to any of the information that's been produced. Acting for the seller, there's a plan of action for you. And acting for the buyer, again, the same thing. Watch information the estate agent has provided to your buyer client. Rosser and Pacifico says that could be just as much a misrepresentation as a response to a question in a TA form. Explain the basic principle of let the buyer beware, but to an extent, Rosser and Pacifico has eroded that concept. Explain to the client the significance of inspection and the fact the client should be using inspection as an opportunity to check the answers that the seller has produced in the TA forms, and check survey and valuation too. Make sure the client has read that and is aware of anything the surveyor or valuer is suggesting requires further attention. The Woodward Fisher case, the famous moth case, very valuable property in central London. Fairly confident that if this had been an issue with regard to £2,000 worth of mouse infestation or something of that nature, we wouldn't have litigated. But because of the value of the property, because of the damage to goods, carpets, curtains, clothing, etc., and because the claimants were exceedingly wealthy, this was a case well worthy of pursuit. This was a fraudulent misrepresentation, said the judge. The seller was well aware of an infestation of moths, which should have been disclosed to the buyer. The buyer had, fortunately for it, instructed pest control experts who had come out to have a look at the moth problem and were unsurprised about it, having been instructed by Mr. Woodward Fisher to look at the problem some time before the property was sold. Thus, in my view, hanging out Mr. Woodward Fisher and his wife to the claim for misrepresentation. Mr. Woodward Fisher contended that he'd asked his solicitors to confirm the status of moths, whether they were an infestation or whether they were vermin, and had been assured that they were neither. But this case does sort of highlight the potential dangers and problems associated with incorrect or defective answers. I've got now a couple of minutes to deal with any questions that anyone may have. We have had a scamper through lots of things that I could talk to you about all day, but we are limited to a lunch and learn session, or as I said earlier, a munch and moan session, and therefore my time is just about up. Anyone got any questions or queries? Any burning issues? If you're interested in common hold training, let me know. If you're interested in any other form of training, again, drop me an email. If you have any burning issues or questions arising from today, send me an email. If I may, Jess, I will share, having anonymized the questions and responses. Happy for you to share amongst attendees. Glynis, are agents wasting their time completing material information? Potentially, Glynis, but I think they're obliged to do it. No problem, everyone. I think on that happy note, if we don't have any questions, we can finish at that. Thanks very much for coming along. Lovely to see you. Thanks, Jess. Thanks, everyone else. And speak soon. Take care, everyone. Thank you. Bye-bye.